Can employment law protect against wrongful termination cases? In recent days, the topic of wrongful termination has gained significant attention. Many individuals are asking, can employment law truly protect against wrongful termination cases? As workplaces evolve, understanding these protections is more important than ever. Employment law does offer safeguards against wrongful termination, but these protections can differ based on location and specific situations. In many areas, employment is classified as at will. This means that an employer can generally terminate an employee for any reason or even no reason. However, there are key exceptions to this rule that protect employees from wrongful termination. One major exception involves discrimination. It is illegal to terminate an employee based on protected characteristics such as race, gender, age, religion, national origin, or disability. If an employee is fired for discriminatory reasons, they may have grounds for a wrongful termination lawsuit. Another important area is retaliation. Employees who report illegal activities or violations, such as workplace safety issues or wage violations, are protected from being fired in retaliation. This protection is crucial, even in at-will employment situations. There is also the public policy exception. Employers cannot terminate employees for reasons that violate public policy. For instance, firing someone for refusing to engage in illegal acts or for exercising a legal right, such as filing a workers' compensation claim, is prohibited. Additionally, the implied contract exception exists. Even without a formal written contract, if an employer's communications or policies create a reasonable expectation of job security, firing an employee against those expectations may be wrongful. In some areas, there is a covenant of good faith and fair dealing. This means employers must act in good faith and cannot terminate employees out of malice or bad faith, such as to avoid paying benefits. For example, in Germany, the law requires employers to provide justified reasons for termination, such as performance issues or operational needs. This contrasts with the at-will system, where such justification may not always be necessary. New laws are also emerging in various regions to enhance protections, some requiring employers to provide notices and opportunities for employees to respond before taking adverse actions based on background checks. When wrongful termination occurs, employees can seek remedies like back pay, front pay, reinstatement, and damages for emotional distress. Courts may also require employers to change policies or provide training to prevent future violations. Common mistakes employers make include failing to document legitimate reasons for termination and retaliating against employees who assert their rights. To avoid wrongful termination claims, employers should comply with applicable laws and maintain clear policies. In summary, employment law does provide protections against wrongful termination. Awareness of these protections and careful adherence to legal requirements can help both employees and employers navigate the complexities of termination cases.